Sunshine State. This is Tampa Bay's 10 Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock. That means it's another live edition of FLA Law on the radio. I am attorney Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes. We're the longest established personal injury law firm in Tampa Bay. We have been helping people since 1955. Next year, we celebrate our 70th birthday of being involved in the community and helping out. Well, and one way we do try to be involved in the community and help out is by putting on this radio show every week. It's a live call-in radio show. We're here to answer questions that you have regarding the law. So if you do have a question, give us a call at 727-441-3000, and we'll be able to answer those questions live on the radio. If you don't want to have your voice on the radio, but you still want to watch the show and send a question, you can jump onto the firm's Facebook page. We're live feeding the show, and that Facebook page is Perenich, Caulfield, Avril Noyes Injury Lawyers, and we're live right now. You can type in your comment or your question right there, and I'm looking at it right here, and I'll be able to answer any questions you have. Again, I'm Matthew Noyes. I'm one of the partners of the law firm, and we specialize in personal injury. Personal injury includes car accidents, workers' compensation accidents, slip and falls, trip and falls, and we even do Social Security disability. So I'm able to answer any questions that you have regarding those areas of law. For those who were listening last week, we kind of had a Hey Matt's episode because I did not have a guest or a co-host on the show last week. Well, this week, it's the same. We got another Hey Matt episode. We talked about the Hey Matts last week regarding automobile accidents. We talked about what type of coverage was important, who pays the property damage, who pays the medical bills, who pays your lost wages, what other damages are you entitled to receive after being injured in an automobile accident. We tackled all those last week, but I'm happy to address those again this week. If you have any questions regarding what to do after a car accident or what are you entitled to after a car accident, what are your rights, but also just as important, what are your responsibilities after a car accident? So if you have questions about last week's topic, give us a call at 727-441-3000, and I'm happy to tackle those questions this week as well. But this week, I thought we shift our focus a little bit to workers' compensation. We'll have Hey Matts relating to workers' compensation. I have been representing people injured at work, for decades now. And it's been an honor to help people who get hurt at work, but it's also kind of frustrating to see how unfair the workers' compensation law is in the state of Florida. The benefits get dwindled down as the statute gets changed, but the rights, the protections also get dwindled down. It's just not fair. It's not right, and that's kind of why we continue to do workers' compensation. It's because we believe that the injured worker deserves a voice in the work comp system, and since our website is Voice of the Injured, we take pride in helping people through the work comp system. So if you have any questions regarding Florida workers' comp, please give me a call at 727-441-3000 or jump on the Facebook page and type in your question there. But I wanted to tackle the first Hey Matt, and it was this from a client. Hey Matt, is every employer required to carry work comp coverage? That's a very good question, and it's a question that too many employers don't really know the answer to. And the answer to that is, in the state of Florida, not every employer is required to carry workers' comp coverage. Many are, but not all. The law states that if the employer has 4 or more employees, they are required to carry workers' compensation coverage. That's 4 or more employees. If they have 3 employees, they are not required to carry workers' comp coverage. And they can exempt themselves as an employee should they desire, which diminishes the number of employees. So if you had somebody, let's call him Joe, running an AC unit, AC business, and he had him and 3 and a bookkeeper and 2 techs, and he exempt himself from work comp, then he would not be required to carry work comp coverage. Many people don't understand that, but that's what the law states. But there's one huge exception to the 4 or more employee rule. And that is if the employer is in the construction industry. Construction industry is defined by Florida's statute having to do with workers' comp. But I won't go over that because it's very detailed. But for the most part, if the employer is in the construction industry, they must carry workers' comp coverage if they have 1 employee. Not 4, 1. If there's 1 employee, they're required to carry workers' compensation coverage. Too many times I represent people that are in the that are in the construction industry or working for a company that is in the construction industry, and we find out that there is no workers' comp coverage because the employer thought, since he only had 3 employees, he did not need workers' comp. But that's totally false. In the work comp arena, if you are in the construction industry, if there's 1 employee, you must have workers' comp coverage. But hey, Matt, what happens if I get hurt at work and there is no work comp coverage available? Well, we see that a lot as well. If there is no work comp coverage available, you can still proceed against the employer. You get an avenue. Actually, you get a choice. You can proceed against them for workers' comp benefits, which we'll go over in other Hey Matts this evening. But you can proceed with workers' comp benefits, or if they were negligent in the way and you got hurt because of their negligence, you can bring a negligence lawsuit against your employer for damages that you sustained because of their negligence. And people scratch their head, and people who are listening to the show may say, well, wait a second, I thought you could not bring a claim against the employer if you get hurt at work. And that is true in all situations except for when they do not provide workers' comp coverage. Let's go over that. Workers' comp is your exclusive remedy. If you get hurt at work, even if it was the employer's negligence that caused you to get hurt, your exclusive remedy is work comp benefits if they have that work comp coverage. You get medical and lost wages, and that's it. You don't get a penny for pain, no pain and suffering, no loss of enjoyment of life, no diminished income, no additional lost wages. Even if the employer was negligent in the way that caused you to get hurt. Not fair, not right, but that's what the law says. I often give a scenario because in my younger days, one of my most favorite jobs was being a waiter at Denny's restaurant. I loved waitering. But the scenario that I give is, let's say that I am walking side by side with a customer at the Denny's restaurant. It used to be on 19 right next to Harn, not there anymore. But let's say we're walking side by side and there's a puddle on the ground from somebody who spilled soup on the ground. It's been there for a while. Nobody came and cleaned it up. And myself as a waiter and the customer both slip on it. We both fall and we both break our leg. We have the same exact injury. We have the same exact lost wages. We have the same exact pain and suffering. But we don't have the same exact cause of action. Me, as an employee, would have the right for workers' comp benefits. That's it. Lost wages and medical, which we'll go over later during the show. The customer who has the same injury and the same damages would be entitled to medical of doctors of their choice, 100% of their lost wages, and compensation for non-compensable damages such as pain and suffering, mental anguish, loss of enjoyment of life, having to cancel that vacation, not being able to ride roller coasters, the continued medical care, all those non-tangible damages they're entitled to, but an injured worker would not be entitled to, as long as the employer carried workers' comp coverage. And that should give employers incentive to carry work comp coverage. But you'll be amazed to find out how many people don't. So before we get to the next Hey Matt on workers' comp, I do want to remind you, I am attorney Matthew Noyes. I am a partner at the law firm of Perenich, Caulfield, Avril Noyes. We put on FLA Law on the radio every Tuesday from 5 until 6 on WTAN 1340 and FM 106.1. We are here live to answer any questions that you have regarding the law. We're not limited to just the topics that we're talking about tonight. If you have questions regarding automobile accidents, Social Security disability, trip and falls, slip and falls, which are two totally different things, or getting hurt at work, we're here to answer the questions you have. We had a client picnic, a client appreciation picnic on Saturday, and it was so wonderful to be available to the clients outside of the office and to be able to talk to them. Well, this is what this radio show does as well. It gives you an opportunity to talk to a lawyer to get your questions answered. So take advantage of it. It's 727-441-3000 is the law line. So give us a call while there's still lines open. Or jump on our live feed on Facebook at Perenich, Caulfield, Avril Noyes Injury Lawyers and type in a question there. I'm happy to tackle those questions. But let's get back to the Hey Matts regarding workers' comp. And the next Hey Matt that often we hear is, Hey Matt, what medical benefits are provided to someone who gets hurt at work? And people are often surprised with the answer. If you get hurt at work, you are entitled to medical benefits. Workers' comp has to pay your medical bills. And that sounds great and that sounds wonderful, but there are many, many things that aren't often known about when we talk about medical benefits under workers' comp. For example, you don't get to choose your doctor. Workers' comp carrier appoints the doctor. They tell you who to go see, and you must go see them. Oftentimes, it is a walk-in clinic. And oftentimes you have to wait in long lines in the waiting room just to get seen for your workers' comp claim. But that's the law. Workers' comp care gets to pick the doctors you treat with. They have to pay for that, but they get to pick the doctors that you treat with. They are also required to provide any care that the doctor recommends. If it's a diagnostic test like an X-ray or an MRI, they have to provide it, but they get to pick the facility. If it's a specialized doctor, let's say they send you to a walk-in clinic and they said, oh my goodness, look, we did X-rays and you need to see an orthopedist. Well, they have to provide an orthopedist, but they get to pick it. They pick the doctor that you have to treat with under the workers' comp law. There is no second opinion in workers' compensation. If you don't like what your doctor says, you don't get a second opinion. There is something in the law, though, that you are entitled to, and it's called a one-time change. It's a one-time change of doctors. If you are unhappy with the doctors that workers' comp assigns you to, you can request a one-time change. It's a one-time change because you can only use it one time for the life of your case. You can't use it for a one-time change in the walk-in clinic, and then a one-time change in the orthopedist, and then a one-time change for the surgeon or for the pain management. It's a one-time change for the life of the case. Too many times people come to me after being hurt at work and they tell me that they already utilized the one-time change before they came to me, and they don't like the second doctor. Unfortunately, there's very little you can do about that once you utilize the one-time change. Workers' comp does not have to provide you yet another one-time change. And so that's why it's so important that you talk to an attorney after you're getting hurt at work before you start giving up benefits that you otherwise may be entitled to. So we're still talking about the medical. They have to provide you medical care for the rest of your life, as long as the work comp injury is the major contributing cause for your need for treatment. Legal mumbo jumbo there. Yes, I know. Major contributing cause. What does that mean? That means that the work injury has to be 51% or more the reason why you need the treatment. That is often litigated, often fought about, because there's a dispute. Let's say that you're a 55-year-old man that done labor for most of your life, and you've had back pain from doing activities. Nothing that stopped you from working, but you've had back pain. You get hurt at work, you lift a refrigerator, and all of a sudden you feel this horrible back pain just stabbing you in the back, radiating down your leg. You go to the work comp doctor, and he says, oh, well, 50% is from the work accident, lifting that refrigerator, but 50% is the way that your back was, or the condition that your back was the day of the accident. Well, believe it or not, what that means is workers' comp does not have to provide you with workers' comp medical benefits or wage benefits because it's 50%. And in order to be the major contributing cause, it has to be 51%. And so that is where there's often a lot of litigation, a lot of battling, whether or not workers' comp is responsible to provide you with the medical care, even though you clearly got hurt at work, even though you never had that pain before, even though the treatment was well documented and there was a gap in treatment before you got hurt. The major contributing cause argument is something that workers' comp carriers raise on a regular basis, and lawyers have to fight it on a regular basis. So, yes, they have to provide medical treatment for the rest of your life, but as long as it's the major contributing cause. And the further you get away from the accident, the harder it is to establish major contributing cause. Another thing that people don't understand is that in terms of medical care, is that under workers' compensation law, remember, they get to pick the doctors. Well, after you reach maximum medical improvement, or MMI, once you reach maximum medical improvement, the workers' comp carrier still has to provide you with medical care, but you have to pay a $10 copay for every visit that you see. Yes, you have to pay $10 to a doctor you didn't choose, that you may not like, in order to get the medical treatment that you need under the workers' comp statute. Medical benefits can be quite confusing under workers' comp. So it's important that you talk to an attorney after you get hurt at work to make sure that you're protecting your rights, but also to make sure that you're doing what you're responsible to do. One of the things that is your responsibility when it relates to medical care is to make sure that you ask for medical care. I've had situations, lately it seems to be more often than in the past, where clients come to me and say, my employer's not giving me any medical treatment. And I want to file a workers' comp claim. And so then I have to ask, I said, well, did you ask for medical care? And the answer not often, but sometimes is, no, I didn't ask for medical care. Well, the law says that if you don't ask for medical care, the employer does not have to necessarily provide it, or the carrier does not necessarily have to provide it. So it's so important that one of your responsibilities after you get hurt at work, that if you need medical care, is that you request medical care. Don't do it verbally. Put it in an email. Send it in a text. Do what you can to document your request for medical care. Because the law does state that if you ask for medical care and they do not provide it, then in some situations, you can pick your doctor. That's the only time you get to pick your doctor. So document your request for medical care. If you have questions regarding the medical benefits under workers' comp, I could go for a whole month talking about different situations about medical care under workers' comp. But let's go to other hey Matts. I want to talk about the hey Matt about wages. But before we do that, I want to remind you, to the new listeners who may just have turned the channel and wondering what this voice is talking about work comp. Well, I'm Matthew Noyes. I'm a partner at the law firm of Perenich, Caulfield, Avril Noyes. We are the oldest personal injury law firm in Tampa Bay. We have been fighting for those injured because of car accidents, work comp accidents, trip and falls, slip and falls for almost 70 years now. Our main office is in Clearwater, but we have offices throughout Tampa Bay. And we're online as well at usalaw.com or voiceoftheinjured.com. So we are here to help you. We are here to guide you. We always believed that part of our job as a lawyer is to give guidance, to give advice, to help people through a system where they may not need a lawyer. There are some situations where you don't need a lawyer after getting hurt at work or even get involved in a car accident. But you need to talk to a lawyer to see if you fall into those situations. That is why we have been around for so long, because we firmly believe that that's our role. And that is another reason why we do FLA Law on the radio every Tuesday between 5 and 6 o'clock, because it is important that you have an avenue, you have a resource to get your questions asked without having to pay an attorney just to ask one or two questions. So take advantage of that this evening. The number is 727-441-3000. We're going to take a short break before we take the next Hey Matt. But please, if you have questions or you know somebody that has a question, please get on the line at 727-441-3000 because we will be back right after this very short break. Be right back.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
We are back. I am Matthew Noyes. I'm one of the attorneys at the law firm of Perenich, Caulfield, Avril Noyes, the one that Paul Porter was just talking about. I love going to the hockey games and hearing his voice as he announces a score for Cooch or whoever else may be the one making those scores. But yes, I am Matthew Noyes. I'm one of the partners at Perenich, Caulfield, Avril Noyes. We are live right now to answer questions that you have regarding the law. I do personal injury. That means car accidents, trip and falls, slip and falls, work injuries, and even Social Security disability cases. So if you have questions regarding those areas of law, please give us a call now at 727-441-3000. Next week, I have my friend and colleague, Patrick Gaffney, as my guest. And he is a board-certified marital attorney, so he'll be able to answer questions that you have regarding family law, divorces, but also family law and other marital situations that doesn't necessarily all end up in divorce. So next week is Patrick Gaffney, but this week you have me, and we are doing our Hey Mats. And we're focusing on Hey Mats regarding workers' comp. Earlier, we were talking about the medical benefits that you're entitled to after a work injury. But now let's talk about the wages. Oftentimes, I'm asked, hey, Matt, what wage benefits do I have if I get hurt at work? That's also a very confusing question, and it is a topic that could last for the full hour. But in general, you are entitled to wages depending on what your workers' comp doctor says about your ability to work. If the work comp doctor says that you are unable to work at all because of the work comp injury, you're entitled to temporary total disability benefits, or TTD benefits, temporary total. But that has to be the work comp doctor who puts you off of work. Can't be a family doctor. It can't be a car accident doctor who you may be seeing. But it has to be the work comp doctor. If the work comp doctor places you off of work, you're entitled to temporary total disability benefits, or TTD benefits. You get TTD benefits for the amount of time that you're unable to return to any type of work. How much do you get paid? Well, you get what's called the comp rate, and the comp rate is 66 2/3 of your average weekly wage. How do you calculate the average weekly wage? Well, you have to go back 13 weeks before the accident and get an average of what you earned during those 13 weeks, and that's your average weekly wage. There are many cases and many a lot of court orders having to do with how to calculate the average weekly wage when somebody hasn't been there for 13 weeks. And there are often sometimes fights about the correct average weekly wage. But for the most part, the average weekly wage is the average of the 13 weeks before you got hurt at work. And you get 66 2/3 of that average weekly wage for as many weeks as the workers' comp doctor has you out of work altogether. Why I stress that is because the next type of indemnity or wage benefits that you would be entitled to under workers' comp is if the workers' comp doctor says, you're hurt, you can't go back to your duties, but you can go back to light duty or duty with other modifications. It may be no sitting for more than 10 minutes, maybe no lifting more than 25 pounds or 10 pounds or even 5 pounds. It may be no use of the left hand. It may be no standing, climbing ladders, or it may be whatever the restrictions or limitations may be. If the doctor places you with limitations, you're not entitled to temporary total disability benefits. Because remember, temporary total meant that you're out of work altogether and there's no ability to return with any limitations. When you have limitations, you would be entitled to temporary partial disability benefits, or TPD benefits. And that is very confusing to many people, because what you have to do, you have to present to your employer these restrictions, and then the employer has to make a determination whether or not there's any work available for you within those restrictions. If there is work available for you within those restrictions and you receive 80% or more of your average weekly wage while doing that modified work, you are not entitled to temporary partial disability benefits because you're getting paid by your employer. However, if you present your modified work to the employer and they say, I don't have any work within those restrictions, you install ACs, I can't have you sweeping the floor, or there's no paperwork to do. We have people already doing all the office work. If there's no work available for you within the restrictions, the employer doesn't have to create a job for you. You would be entitled to temporary partial disability benefits. Remember, TTD was that you got 66 2/3 of your average weekly wage. TPD, temporary partial disability benefits, is a quacky calculation. What it is, in order to calculate the TPD benefits, they look at what your 80% of your average weekly wage was. And then they say, okay, you were released to modified duty. Did you earn 80% of your average weekly wage? If the answer is no, then they'll take 80% of the 80% of your average weekly wage. Yes, my head spins too, so I understand 100%. However, if there is work available for you within the modified work, but it's not your job and they decide to send you back to work at a reduced pay or reduced hours, then you could still be entitled to temporary partial disability benefits. It would depend on how much you earn at the job that you're working. If you earned 50%, then you would get a check from your employer for the hours that you worked. And then you would get a check from workers' comp for temporary partial disability benefits as well. And they do that same calculations. They say, okay, has he earned 80%? Oh, no, he didn't earn 80%. He only earned 50%. And so therefore you get 80% of the difference between 80% of your average weekly wage and what you made from the employer. This is why it's so confusing for an injured worker to handle the workers' comp case by themselves. Too many times, these wages are not calculated correctly. It's important that you talk to an attorney if you are released back to work to make sure you know what your rights are, but also what your responsibilities are. One of your responsibilities is to give your employer the restrictions. Another very important responsibility is to try the work that's offered. If you refuse to try work that is offered, I envision the work comp adjuster getting on top of the table and doing a little jig, and the employer as well, because they do not have to provide you any wages or even temporary partial disability benefits because you're refusing employment. It's voluntary limiting your income is the magic legal words. If you voluntarily limit your income, you're not entitled to temporary partial disability benefits. And of course, you're not entitled to wage benefits because you refused the light work or the modified work. It's so important that you talk to an attorney before you decide to refuse any work that's being offered to you. I have a case where the workers' comp carrier told my client, their employee, listen, we don't have work available for you, but we'll send you over to the local Goodwill thrift store and you can do work for them at a reduced rate. Of course, my client's like, I don't want to do that. I can't do that. I can't stock and stand and do all the merchandising with the restrictions. And that's not my employer. Sadly, the law says that you got to try it. If you refuse to try it, they don't have to pay you. And I think sometimes that's why workers' comp carriers assign those types of jobs, because they hope the injured worker refuses to do it. But that doesn't mean that you have to do it and be in pain. If you try work, the modified duty work, what I always tell my clients is to try it and record what kind of activities they're making you do and which of those activities cause you pain. And then go to your workers' comp doctor and share that information with them. They may modify your restrictions to prevent you from having to do those duties as well. But if you just refuse, saying, I know I can't do it, I know I'm in too much pain, then the workers' comp judge doesn't have any power to award you temporary partial disability benefits. Yes, those are two of the main wage benefits you're entitled to. I'm going to just briefly talk about one more, and that's called PTD benefits, and that's permanent total disability benefits. And that is when the workers' comp doctors conclude that you can't go back to any type of work because of your work comp injury. You can't go back to even sedentary work because of your work comp injury. If you are able to establish that you can't even perform sedentary work, you may be entitled to permanent total disability benefits. And they have to pay permanent total disability benefits each week up to the age of 75. How much? It's that same rate that you receive from temporary total. So it's 66 2/3 of your average weekly wage. There's also supplemental benefits that you would be entitled to, which increase every year. But it's important that if you feel and your doctor feels that you can't go back to any type of work, even sedentary work, it's important that you talk to an attorney about your rights under PTD or permanent total disability benefits. So in a nutshell, that's the wage benefits you're entitled to. Medical, we talked about, they get to pick the workers' comp doctor. You get a one-time change, and that's it. And wages, you get temporary total if you're out of work altogether, temporary partial if they say you can go back to work, and there's no work available for you, or no work available for you to earn 80% of your average weekly wage, or permanent total disability benefits if you're unable to work even sedentary work. Those are the three main wage benefits. I would be remiss if I didn't tell you that those temporary benefits, the temporary total and the temporary partial, end once you reach maximum medical improvement. It doesn't matter if you're back to work or not. If you're at MMI or maximum medical improvement, your wage benefits end whether you have a job or not. That is why I always encourage my clients not to rush maximum medical improvement. Yes, you want to get back to work, but you do not want to rush maximum medical improvement, because then your wage benefits end unless you're permanently and totally disabled. So those are another key thing to know about the wage part of the workers' comp system. So the next "Hey, Matt" that I often hear in workers' comp is, "Hey, Matt, can I settle my workers' comp case?" And the answer to that is, well, maybe. And yes, that's a typical lawyer answer, but there are situations in time where you can settle your workers' comp case. However, a work comp case is not like an automobile accident case. Workers' comp settlements are voluntary, totally voluntary. Voluntarily on the claimant's part, on the injured worker's part, and on the workers' comp carrier's part. If one side does not want to settle the case for any reason, no judge or jury can force the other side to settle the case. Too many times, the one party just decides to keep the case open because they don't want to pay the injured worker. They think they're going to pass away because of their age or because of their disability, or the injured worker doesn't want to settle because there's too much medical care that is needed, and they rather have the comfort of knowing that workers' comp is going to pay the medical care. But what is a work comp settlement? A work comp settlement is kind of like a divorce, kind of like what Patrick Gaffney is going to talk about next week on FLA Law on the radio. But it's kind of like a divorce from workers' comp. They agreed to pay you a lump sum amount of money, and you agree never to bother them again. What's that lump sum amount of money? It depends on what you are going to cost them into the future. Many times you don't want to talk about settling your case until you reach maximum medical improvement. So if you reach maximum medical improvement and you're not permanently and totally disabled, the only thing you're going to cost the work comp carrier is medical care. It may be injections. It may be surgery. It may be, just palliative care to maintain your condition. But you are going to cost them something in terms of medical care. So oftentimes they want to settle the case. They want to pay you a lump sum to wash out your medical case. And if you agree to that, then they give you the money and you have to see who you want when you want for your medical care. You cannot go back to workers' comp to ask them to pay for medical care. Many times, I've had situations where a client comes to me and says, I settled my case because I really needed the money and I was having back pain, but I settled the case. But now I had an MRI and it shows I have a herniated disc and I need surgery. I want to reopen my workers' comp case. And unfortunately, I have to be the bearer of bad news and tell them, well, sorry, you settled your case prematurely and you cannot reopen your workers' comp case if a new injury is found. So that's why it's so important that you talk to an attorney before you settle the workers' compensation case, because you are releasing the work comp carrier from any and all responsibilities into the future, whether it's medical or whether it's even wages. And so, but a lump sum settlement can be done in situations, but you have to be wise in doing a lump sum settlement in a workers' comp case. It has to be at the right time and for the right amount of money. Otherwise, you keep your case open and you make workers' compensation pay. Which brings me to hey, Matt, how long does my case stay open? Well, your workers' comp case stays open as forever and ever and ever until you die, as long as you see a workers' comp doctor at least once every year. If you let 1 year go by after the initial 2-year period, if you let 1 year go by without seeing a workers' comp authorized doctor, then that jig I was talking about on the table, I see the adjuster doing that jig again because they don't have to pay for any more medical care because you let the statute of limitations run. And even if you need more care, and even if it is related, they do not have to pay because the statute of limitations had run on the case. So it's so important that you document the treatment with your workers' comp doctor. And it can't be any workers' comp doctor. It can't be, hey, I saw Dr. Jones and he takes workers' comp. No, you have to see your authorized workers' comp doctor in your case at least once every year in order to keep your case open, unless you settle the case. That's so important. We see that way too many times that that a year and a day, a year and a month goes by without any treatment, and workers' comp's off the hook for any more future medical care. So that's important. So the easy answer is yes, you can settle your workers' comp case, but do it wisely, both in terms of the amount and also in terms of the timing. You don't want to settle your case too early. Also, just a little caveat about when we're talking about settlement, that if you are entitled to Medicare benefits because of your age or because of your disability, they need to be taken into consideration when you're talking about a lump sum settlement. There's something called a Medicare set-aside allocation that if you are even thinking about settling your workers' comp case and you are eligible for Medicare, you may be eligible for Medicare in the next 2 years, do not settle your case without talking to a work comp attorney first. So important. And so let's go to the next hey, Matt. And the next hey, Matt is, okay, Matt, I followed all the directions that you told me. I reported it to the employer. I requested the medical care, and they're still not giving it to me. What can I do? Welcome to my world. This is what we do on a daily basis for many, many clients. workers' comp's supposed to be a self-executing system. You're not supposed to need an attorney to get the work comp benefits you're entitled to. Unfortunately, you do in some situations. After a work comp benefit is requested and not provided, there is a situation and a step-by-step process that you need to go through in order to secure those benefits. And the first step you have to do is you have to send what's called a good faith notice. And again, this is something that an attorney should be doing and really not a claimant themselves. But the attorney would send out a good faith notice saying, hey, we requested X, Y, or Z, let's say an MRI or wage benefits. We requested, you haven't provided. Please provide within a reasonable time. Otherwise, we're going to take the next step. If they provide it, great. Then you don't have to take the next step. But if they don't, which most times they don't, you have to take the next step. And that's called filing a petition for benefits. You have to file a petition for benefits with the courts. Unfortunately, many claimants don't know how to file a petition for benefits. And you have to e-file it. And it's very hard to e-file anything if you're not an attorney. But the next step would be a petition for benefits. And that is asking the court to tell the carrier to provide the benefits that you've already asked for 2 or 3 times. You have to attach documentation to that petition for benefits and then submit it to the judge. The workers' comp carrier has 30 days to respond to the petition for benefits without any penalty of attorney's fees or cost. If they let 30 days go by without providing the benefit, then they are on the hook for paying your attorney's fees and your attorney's cost as it relates to those benefits once those benefits are secured. And the 30 days after the petition for benefits is really starts the process. We take the depositions of the doctors if need be, if it's a medical request, or we take the adjuster's deposition or the employer's deposition, all the depositions that we need in order to support our claim. We then go to a mediation, a state-ordered mediation. And after that mediation, we go, if it cannot be resolved, we go to a final hearing in front of the judge. It's just a final hearing in front of the judge. You do not get a jury in workers' comp. That's the system that you have to go through, and you can't do that alone. So it's important that you go through an attorney. If you have questions regarding workers' comp, Social Security, or auto accidents, call our law firm at 727-796-8282 or visit us at voiceoftheinjured.com. It's been an honor to be here for the last hour. I am Matthew Noyes with the law firm of Perenich, Caulfield, Avril Noyes. I'll be back next week, but in the meantime, drive safely and watch out for those who don't. Take care.